In an important development, the Karnataka High Court recently rejected the argument that a minor Muslim girl's marriage upon attaining puberty, that is 15 years of age, will not contravene the Prohibition of Child Marriage Act of 2006. Justice Rajendra Badamikar of the Karnataka High Court was adjudicating upon the bail plea of a man who had married a minor Muslim girl. The High Court further observed in this order that the POCSO Act is a special legislation and that it overrides personal law, and as per the Act, the age for involving in sexual activities is 18 years of age. The order comes days after the Punjab and Haryana High Court reiterated that a Muslim female aged 15 years and above can marry a person of her choice on her own willingness and consent, and that such a marriage would not be void in terms of Section 12 of the Prohibition of Child Marriage Act of 2006. Essentially, in this particular case, the accused had been booked for the offences punishable under Section 9 and 10 of the Prohibition of Child Marriage Act of 2006 and Sections 4 and 6 of the POCSO Act on the ground that he had married and impregnated a minor Muslim girl. This particular case before the Karnataka High Court came to light when on June 16th, the victim, that is the wife of the accused, approached the primary health center for a medical checkup, and on examination it was found out that she was pregnant. Further, it was revealed that she was aged about only 17 years. Thereafter, the Sub-Inspector of Police of the KR Puram police station lodged a complaint against the petitioner. Seeking bail before the High Court, his counsel argued that under Muslim personal law, puberty is the consideration for marriage and that normal puberty age is treated as 15 years, and hence in this particular case, since the girl had already attained puberty, there was no commission of offence under Sections 9 and 10 of the Child Marriage Restraint Act. However, the High Court categorically rejected this particular argument by stressing that the POCSO Act is a special act and it overrides personal law, and as per the same, the age for involving in sexual activities is 18 years. However, taking into account the fact that the victim was aged about 17 years and was capable of understanding things, the High Court went on to observe that there was no evidence to show that she raised any objections to her marriage, and therefore it was prima facie evident that she was also a consenting party, though she was under the influence of her parents. Admittedly, the petitioner is the husband of the victim, and looking to these facts and circumstances, there is no serious dispute regarding the marriage, as the petitioner himself has produced the relevant documents before the trial court. The High Court further added, as it granted bail to the accused on him executing a personal bond for a sum of Rs 1 lakh. It may be noted for our viewers that the Supreme Court is set to examine the question if a minor Muslim girl can marry on attaining puberty, as it recently issued notice on the petition filed by the National Commission for Protection of Child Rights, that is the NCPCR, challenging a recent judgment of the Punjab and Haryana High Court, which had held that a 16-year-old Muslim girl can enter into a valid marriage. Thank you. I'm Rajendra Badamikar for LiveLaw. Keep watching LiveLaw for more such updates.